So, morning everyone, and thanks for joining us on this service charge and first year tribunal webinar that Zoe and I are going to be presenting. Just before we make a start on the webinar, just a bit of housekeeping. The slides are going to be made available to those who are attending after the session, so there's no need to furiously make notes or try and keep up with us if you're finding that difficult. So you'll be able to refer to those afterwards. We'll try our best to answer as many questions towards the end. So if you do have any questions about this session or any of the issues that we've raised or touched upon, please do send us your queries, and hopefully we'll try and get around to addressing those at the end. And also lastly, the feedback sheet, which would be useful for us if you can complete, as that not only tells us how we're getting on with our presentations, but also gives us some ideas for topics and some of the issues that are sort of pressing in your mind that we can address in some of our future webinars. So as I said, we're looking at the first year tribunal and service charge disputes this morning, and how best to try and deal with those and manage those. And I'm going to start mainly talking about service charge areas, and then Zoe's going to talk about the first year tribunal and some of the rules that you can use and that might be available for you to manage cases in an effective way and try and minimise the time and expense of dealing with these types of disputes. So as I said, Zoe's going to talk about the FTT and the particular rules, but obviously this is where a lot of the service charge disputes that you'll be dealing with find their way to and get dealt with. This is really the forum where the service charge disputes get heard. And as I said, until 2013, so when I was practicing, and there's still a sort of throwback and the temptation to refer to it as the Leasehold Valuation Tribunal, as that's its old name, but the first year tribunal sort of came into effect in July 2013. And as a result of that, and effectively as a result of the provisions under the Common Hold and Leasehold Reform Act in 2002, effectively the disputes that the tribunal can consider have been widened, and the elements of service charges and the areas of dispute, as I say, the tribunal can consider have widened and been expanded upon quite considerably. So that's by and large, although we'll see that the county courts can also deal with these service charge disputes. Traditionally, you will find yourself in a first tier tribunal setting if a formal dispute about service charges is raised. So that's why it's important to be aware of the tribunal. So what I said, as a result of the changes to the tribunal system in 2013, the jurisdiction and the types of things that the tribunal can deal with have been expanded upon, and traditionally what these now encompass are service charge disputes, disputes also concerning administration charges, applications to vary leases. So there's various statutory provisions that enable parties to apply to vary their leases in certain circumstances. You can also apply to the first tier tribunal to make a determination on a breach of a lease. So there might be circumstances in which you need to effectively get a finding that there has been a breach of lease in the first place, which will allow you to move on to the next step, such as serving of Section 146 notice and potentially pursuing forfeiture. So the tribunal is able to make determinations on whether or not a breach has occurred. And the tribunals can also deal with Section 20 consultation dispensation applications. So those of you who deal with Section 20 consultation processes with residents will know that it can be sometimes difficult to get it right, or there's certain circumstances in which it can be difficult to actually meet the consultation process and meet the timescales. And you might need to apply to the first tier tribunal for dispensation from the Section 20 process in order to enable you to recover service charges over and above the statutory cap. And I know we've got different sessions on service charges and Section 20, so I won't go into great deal of detail on those, but it's obviously a webinar in of itself, but it's just another area that the first tier tribunal can deal with and consider. Other issues that the tribunal can deal with are issues concerning provisions for insurance in the lease and whether or not they're satisfactory and actually do what needs to be done. There's also appointment of manager. So leaseholders or residents can apply to appoint a manager if they think that their property or their block isn't being managed effectively. And then they've also got they can also deal with issues such as rent setting, and rights of first refusal and enfranchisement, which is sort of either lease extensions or purchasing the freehold of premises by leaseholders. So quite a wide and broad scope that the tribunal can deal with. So there's a lot of issues there that you might find yourself being heard in the tribunal. So as I said, that's why it's worth being aware of these. One of the points to stress, though, is that we're talking about residential premises here when we're talking about first tier tribunal. We're not talking about commercial premises. So commercial leaseholders or commercial landlords won't have recourse to bringing claims or challenges or disputes in the tribunal. They'll be limited to some sort of contractual claim or claim in the county court, but they won't be able to refer their court to the tribunal. So unsurprisingly, one of the most prevalent areas that we find we have to deal with, particularly in relation to tribunal hearings and tribunal directions, is in relation to service charges and service charge disputes. I think anyone who's managed leasehold properties know that leaseholders will have a vested interest in having quite a lot of oversight and input as to what they pay at the end of the day, and you'll find that the particular leaseholders who take a great deal of interest in how much they have to pay, and whether or not the sums that they're paying are the right amounts or whether they think they're paying too much. Obviously, if someone's having to pay potentially a considerable amount of money towards service charges, it's understandable that they want to potentially scrutinise those. So as a result of that, it's these types of cases and disputes that often find themselves in the tribunal if they can't be resolved between the parties by way of negotiation or by way of discussions and conversation. So the tribunal, as I say, has got quite a wide jurisdiction as to what they can deal with in relation to service charges. So firstly, as we see, they can determine whether or not a service charge is payable in the first place. So that'd be a determination as to whether or not a lease provides for a particular cost that can then be passed down by the service charges. The tribunal can also decide who is the person who has to pay the service charges, then who is the person who actually gets paid, i.e. who is payable by way of the lease. Tribunal also gets to decide the amount payable and the date at which something is payable and how it is payable. Again, they can make determinations as to what the leases provide for. But as you can see, it's quite a wide area and quite a wide scope that the tribunal can deal with. Having said that, the tribunal is really only focused on and only has jurisdiction to deal with variable service charges. It doesn't have jurisdiction to deal with fixed service charges. So as a result of that, the scope for residents to challenge their service charges, if they are of a fixed service charge, is obviously much less, and they have far less scope to actually get into the detail and raise challenges over, for example, the reasonableness of a service charge. Whereas anyone who's paying a variable service charge is going to potentially be able to refer their case to the first tier tribunal, as they're going to have jurisdiction to deal with variable service charges. And it's just worth mentioning, just before we go on, that as far as variable and fixed service charges are concerned, there isn't necessarily a definition of a fixed service charge. It's very much a matter of interpretation as to what a lease, for example, provides for, or a tenancy agreement provides for in relation to the service charge provision. But what you're really looking for, and where the definition of variable service charge is found in the Landlord and Tenant Act 1985, is that it basically varies depending on the cost that you are incurring as a landlord. So if you're you would expect the service charges to change from year to year depending on the actual costs that the landlord is incurring from year to year. There might be years that are more expensive as far as the landlord is concerned, and therefore the higher cost will be passed down, and then you can have a year where there's not very much in the way of services being provided, and the lower cost will be charged to the leaseholder, so it would vary on that basis. So as I've already mentioned and touched upon, while most challenges for service charges will find their way to the first tier tribunal, the first tier tribunal doesn't have sole discretion and sole jurisdiction over service charges and service charge disputes. The county court equally can hear disputes over service charges, and often we will see that a lot of service charge disputes might arise out of money judgment claims where service charges aren't paid, and a landlord pursues a claim for money judgment in the county court, at which point the leaseholder or the resident raises queries and disputes regarding the service charges and challenges, for example, whether or not they're reasonable, and says that they've been asked to pay too much. At that point, the county court will often refer the case to the first tier tribunal and move it over to the tribunal to deal with, as opposed to the county court continuing to run with it. There might be circumstances in which you want the county court to continue dealing with it. You might have greater faith in the county court's ability to deal with more complex issues. For example, complicated issues over interpretation of leases, but our experience so far is that by and large county courts are more than happy to refer cases to the first tier tribunal, almost certainly, not least because of their limit of dealing with cases as it is, so in case they can move on to another forum, I suspect the courts are more than happy to do. So although cases, as I say, can be dealt with in county courts, service charge disputes by and large tend to find their way one way or the other into the first tier tribunal. So it's important to know that as far as the challenges that leaseholders can bring, they're not limited to challenging costs that they've actually incurred or been asked to pay. They can potentially challenge future costs, and equally a landlord might want a determination in their favour that future costs are payable, so that there's no uncertainty, or it might minimise the risk of challenge from the other leaseholders. So it's worth bearing in mind that you can get a determination or finding from a tribunal in respect to costs that haven't actually been incurred but are really anticipated or may well be incurred. It's also the case that service charges can be challenged even if they have actually been paid. So it used to be the case under the old regime that if service charges have been paid, then you couldn't challenge those, and obviously that put the leaseholders or residents in quite an unfair position, because they were basically between a rock and a hard place. If they didn't pay, they potentially put themselves in breach, and if they did pay, they wouldn't then be able to challenge the service charges. So the rules now have been changed so that even if they pay the service charges, they can still go back and challenge those at a later date. So again, the leaseholders can protect themselves by not putting themselves in breach at least, but at the same time still retaining the possibility and the option of challenging the service charges. So also the FTC's jurisdiction can't be restricted by sort of contractual terms in the lease by removing the FTC's jurisdiction. So you can't put in sort of clever clauses in the lease to restrict leaseholders' ability to find their way into the first tier tribunal. So in reality, a leaseholder or a resident with variable service charges is going to almost certainly, as long as the challenge falls within the first tier tribunal's jurisdiction, is almost certainly going to be able to find their way into the tribunal. It's also worth bearing in mind that applications in respect of the service charges don't necessarily have to be made by the immediate tenant. If you've got situations where that you have an intermediate or leaseholder as a effectively as a landlord, and then there's subtenants. Those subtenants could bring a challenge in the FTT. And we see this in quite a few examples where we've seen cases of a freeholder who could be a commercial entity who have then granted a long lease of a block to a housing association, and then housing association has sublet each of the units within the block on shared ownership leases, for example. And although under the leases, in respect to the shared ownership leases, the housing association is the landlord and for all intents and purposes charging the service charge, the subtenants could potentially challenge the head landlord's costs if it is the head landlord who is actually incurring the service charges and actually incurring the costs that have been passed down by the service charges. So effectively, the subtenant could leapfrog over the housing association intermediate leaseholder and look directly to the freehold owner who's actually incurring the costs. In theory, and this is always one of the issues that we get asked as to how far back leaseholders can go when challenging their service charges. In theory, there is no limitation as to how far back they can go. They could, other than as far back as the beginning of the lease or as far back as when they've been charged service charges, if that's what they want to challenge. The reason for this, well, potentially because the challenges are often brought under a statutory provision under Landlord and Tenant Act 1985, the standard limitation periods in relation to contract or agreements made under a deed don't necessarily apply to service charges where they're being challenged under a reasonableness provision. And in that case, in theory, as I say, a leaseholder could potentially go back to whenever as far back as they want, potentially as far back as when they've been paying service charges. But in reality, there's case law, one of the main ones being Islington and Kane, which basically says if there's been a pattern and a course of conduct by the leaseholder where they've been paying service charges, they're going to find it difficult to really genuinely challenge going back many, many years if they've been paying for those years. And really, leaseholders are expected to challenge within the first year or two if they're really going to bring a challenge. And traditionally, first-tier tribunals would limit claims anyway to the previous 6 years. Having said that, if the landlord is relying on the contractual provisions in the lease to demand payment, then there might be limitation periods in relation to demands under the contract, or in respect of the 12-year period for agreements made under deed, or 6 years in respect of rent and non-deed contracts. The FTT does have limits on what it can consider, though, and although challenges can still be brought in relation to service charges that have been paid, there's no jurisdiction available to the first-tier tribunal to deal with service charges where they've either been agreed or admitted by the tenant. So effectively, if you're a landlord and you're trying to limit the scope for challenge by the leaseholder or by a tenant, then often what you will try and do is get an admission from the leaseholder that they actually owe the money due, or they actually have breached the agreement in the way that they say they have, or that you say that they've breached it. Because if they admit it, then they can't subsequently go back and then challenge that at a later date and try and seek to overturn that. But as I said, simply making a payment, for example, isn't an admission. Having said that, if both parties have already agreed to refer a matter to arbitration, and as I say, both parties need to agree to this, then again, the FTT can't really look behind that. And equally, if a court, if a county court, for example, had already made a determination or had already made a finding in respect of outstanding service charges, then the FTT can't revisit what the county court has already decided upon. So it may well be that you've got a money judgment in the county court, and then a leaseholder try and seeks to challenge that at a later date after you've got the money judgment, where it's going to be a bit late at that point. You've already got an issue decided by the county court. It's also worth considering that the FTT can't actually make orders with any teeth, as it were. They can't really sanction or require payment or make orders for injunctions compelling people to act in a certain way or not to act in a certain way. So you might be able to get a determination, or you might be able to get a finding that a particular service charge is payable or not payable, but actually enforcing that and taking steps to actually recover any payments that are due will then have to be referred back to the county court at that point in time, when if following the determination someone isn't actually doing what they should be doing and complying with the order. Whenever we do the leasehold training, we always really try and emphasise that the key document and the starting point for really all the disputes is the lease, and to a large extent the issue is no different for the first tier tribunal. They can't really go beyond the terms of the lease to a large extent. What they are involved in is either applying the terms of the lease or interpreting the terms of the lease and giving the lease effect, but they can't really go beyond it. So in reality, for example, they can't make orders or give any extra time for payment if the lease says payment needs to be made on a particular time. They can't really make decisions in respect of changing necessarily apportionment provisions in respect of the service charges, although there's some cases that deal with that specific element, but by and large you're looking at applying and using and interpreting the terms of the lease as your starting point, and that's what the tribunal are really going to be bound by, and working with the parameters of that document. One of the exceptions to that, though, is in relation to legal costs and that arise in the first tier tribunal, particularly in relation to those costs being passed down by the service charges. So this is often referred to as a Section 20C order. So the first tier tribunal does have discretion to effectively override a provision in the lease which allows the landlord to recover its costs of dealing with a dispute, for example, in the first tier tribunal, and recovering those costs via the service charges. Effectively, the tribunal can say that, look, you've brought a claim in the tribunal, that claim was successful, so it's not particularly fair on the leaseholder who has been successful in their challenge that they still have to pay for the privilege of being successful, and that the landlord is entitled to pass down their costs of dealing with that dispute via the service charges. So the first tier tribunal, as I say, can make what's called a Section 20C order and prevent the landlord from recovering its costs via the service charges. So it's one of the limits where the FTT can effectively override what the terms of the lease normally provide for. And then one of the really useful cases, particularly which is used in conjunction with case management powers, which Zoe's going to talk about in a bit more detail, is the case of Birmingham City Council and Keddy. And before the Keddy case, it was quite common for the first tier tribunal to take quite an in-depth analysis of particularly leaseholders' claims, and really look into issues that possibly the leaseholder hadn't even raised. And often the first tier tribunal would effectively force the landlord to undertake an audit of the best part of 6 years of its service charge accounts, and then have to justify that, even though a leaseholder may have only asked to review a particular cost in relation to a particular service for one particular year. And it wouldn't be uncommon for the tribunal to really go off on a tangent and start asking questions that no one else was asking. And this sort of came to a head in the Kelly case, and effectively it was decided that the tribunal shouldn't widen the challenge beyond what is actually being raised by the leaseholder in bringing the challenge, or the landlord, if it's the landlord who's bringing the claim, should really focus on the issues that are actually being raised by those involved, those parties, and not decide to carry out its own inquiries. It should really be limited to what the parties had asked, and also it should really focus on what the parties are asking, so that you don't have a situation where you end up at a hearing carrying out an audit of all the service charges over the last 6 years. Instead, the hearing should be really focused on the issues that are being considered and raised by the parties at the outset. And if it's not clear what those issues are, then they should really be narrowed down at quite an early stage, so that you're not wasting your time and everyone's incurring a lot of time and expense of trying to get to the bottom of what it is that someone is actually challenging. So the Kelly case is quite useful in that regard. And then I'm just going to touch on dispensation before I hand over to Zoe. So as I say, and I mentioned earlier, Section 20 is a process that landlords need to go through when they're looking to recover costs over a certain amount. There's a statutory cap for works of £250 per leaseholders, and then there's a cap on the amount that can be recovered in relation to what are called qualifying long-term agreements, and there's a £100 cap on the other leaseholders. So if a landlord does not carry out a consultation process where it should carry out a consultation process, it will be capped at those sums, which, if the amounts being recovered from the leaseholders is relatively low and not a significant sum over and above the cap, then that might not be that problematic. But if there are cases where landlords are looking to recover thousands of pounds and sums far in excess of the caps, then obviously not complying can have considerable financial consequences if you really held to those caps. But the FTT has jurisdiction to consider when consultation process doesn't have to be complied with, and it can grant what's called dispensation from the consultation process. And really the leading case on that, and really which sets out guiding principles that the first tier tribunal is to follow, is the Dejan Properties and Benson case, and basically that set out a test as to when dispensation should be granted and what the tribunal needs to look for. And really the key issue in whether or not dispensation should be granted is whether or not the residents have been prejudiced by the lack of consultation. So if the residents can show that had they been consulted, the outcome would have been different, or they would have paid less, or a different contractor would have been appointed, or different works would have been done, and lesser works would have been done, then they may well have an argument that dispensation should not be granted, and that they should, and that any service charges that are passed down to them should either be capped or limited in some way because of that lack of consultation. On the flip side, though, if the residents can't show that they've suffered any loss or they've been prejudiced in any way, then it's the starting point is that dispensation should be granted. So at that point, I'm going to hand over to Zoe. I'm just going to share my slides.
Yeah, thanks, Neil. I think I've got control. Good morning, everybody. I'm not doing many slides today, just 3. So I'm taking you through the tribunal's rules, then a quick look at applications to the tribunal, and then finally some practical steps. So the first slide deals with the tribunal procedure. First tier tribunal property chamber rules 2013, excuse me. They obviously gave them a nice short snazzy title. So obviously in the county court, you have the civil procedure rules and their rules, and there's a significant number of them that deal with applications to be made, the way you structure your claims, etc. The tribunal has some similar rules, but they're a lot less There's a lot less in number than the court procedure rules, and they tend to be a lot less formal. There were some important procedural changes brought about by these 2013 rules, and I've just pulled out some specific rules that I think will assist. So first, the overriding objective, and that's similar to the civil procedure rules, the overriding objective there. It deals with parties' obligations to cooperate with the tribunal as well. The overriding objective includes things such as dealing with cases in a fair and proportionate manner, having regard to the complexity of the matter and sums involved. It wants to avoid unnecessary formality and be flexible. So it's much less formal than if you're bringing proceedings in a county court. For example, there's no need for a solicitor. Parties can represent themselves. Someone else can represent you at a hearing that isn't a solicitor. These rules want to make sure that everyone is fully able to partake in the proceedings, and they wish to avoid delay where possible. Rule 4 is a push for alternative dispute resolution. So the tribunal try to let or to push or propose that parties do mediate or undertake some other form of alternative dispute resolution before or during a claim. The tribunal generally have no issue with you adjourning a claim for a few months whilst you attempt to partake in some form of mediation. Rule 8, now this adds a bit more teeth. It's the powers for failure to comply with rules, and Section 9 is striking out Rule 9 is striking out a party's case. I talk about things that you might get a strikeout for in, I think it's the next slide. But for example, if a party doesn't comply with directions, or the one of the parties is vexatious, for example, you can apply to have the case struck out or for some other sanction for non-compliance. And Rule 13, the tribunal can order one party to pay the other party's costs. So unlike with county court claims, there isn't a general rule that the losing party pays the winning party's costs. The general rule is that each party pays their own costs. Now, there is a rule that the tribunal can make an order. The tribunal will make an order if it's satisfied that one party has engaged in unreasonable conduct. Now, I think it's quite a high bar to get over, and my experience says that it is. I haven't seen a lot of these orders made in my time. They're generally very difficult to get. Unreasonable conduct, I'd say, does have a high bar, but you can use it as a stick to beat the other side with. If you think they are behaving unreasonably, you can refer to these rules and state that you will ask a tribunal to make that kind of order, and that sometimes does bring them into line. The next slide is applications to the tribunal. So most cases are brought by a direct application to the first tier tribunal. If it's a service charge challenge, it's likely to be a first tier tribunal application rather than a court application, which Neil's already talked about. And if you look at, for example, the Leasehold Advisory Service website, that directs people generally to the first tier tribunal rather than the court for those kind of disputes. A claim can be brought by the freeholder, an intermediate leaseholder, or a ultimate leaseholder tenant. There are specific application forms for some types of application. These are generally quite helpful if your dispute does fall within one of these. So certain types of application includes, for example, applications for a determination of liability and reasonable of service charges, which Neil's discussed in detail, applications to determine premiums for lease extensions, lease variations, and Section 20 dispensation, which Neil's also talked about, although that's not an exhaustive list. That's just some of the applications that have a specific application form. If there is no specific application form, you can simply make your application by letter to the tribunal, although there is specific information, prescribed information, which does need to be provided in that letter. So, for example, your name and address, the name and address of the person or the company that you're complaining about, the address of the property that the dispute relates to, and reasons for making that application, and ultimately what you're wanting to achieve, so what order you'd like. It's likely a fee is payable, so if a fee is payable, you pay that fee with the application. Part 3 of the 2002, the Commonwealth and Leasehold Reform Act 2002, gives all courts the general power to transfer proceedings to the FTT if the type of case falls within the FTT's jurisdiction. And Neil's already talked to you about cases that do fall within the FTT's jurisdiction. So an example, and I think Neil has already used it, is where a complainant, so a landlord, has brought a claim for unpaid service charges, and they've brought that in the county court. Essentially, they want a money judgment as a precursor to forfeiture proceedings. Someone may defend that on the basis that the reason he hasn't paid those service charges is because he disputes the amount of charges payable or disputes the services provided. It's likely there that a court will stay those proceedings and pass those proceedings to the tribunal to make that determination. Once that determination is made, it will then be passed back to the county court. So that's one example of where the courts will utilise that power. If that is used, Civil Procedural Part 56 applies, and that's that notice of transfer must be given to all parties, and all papers in the county court claim must be sent to the first tier tribunal. Oh, sorry, I've gone on one too far. So practical steps. So you use the Keddy case that Neil's already talked about to limit challenges and narrow issues. So challenges aren't a wholesale audit of the landlord's behaviour for the past 6 or 12 or however many years. If an application, for example, seems to be widening itself to including issues that aren't necessarily relevant to the core issues within the claim, extra things are being added, then try as a landlord or as a tenant, if it's the other way around, to challenge and either strike those issues out or narrow the issues back to exactly what the initial application was made. You don't want it to be an audit of your practices for the last 6 years. So apply to strike out or narrow down some issues and invite the first tier tribunal to use its case management powers that we've already talked about. So we've already talked about the overriding objective, which is to deal with cases fairly, quickly and proportionately. If additional matters are being brought into the claim that aren't necessarily relevant, then arguably that's not using the tribunal in the correct way that it should be. It's not dealing with cases quickly, fairly and proportionately. Now, the tribunal may consider striking out in the following cases. If a person is bringing the application being spiteful, vexatious or petty, for example, so if you have a repeated vexatious litigant who has an issue with a landlord and repeatedly brings tribunal claims that generally have no grounds, then you might be able to get a strikeout on that basis. If the same parties and issues as previous tribunal applications are brought, so if you find a tenant trying to bring a new claim, essentially for an issue that's already been subject to determination, you might get a strikeout there. If a party has a repeated failure to comply with directions, 1 or 2 failures to comply or minor discrepancies in complying are not likely to lead to strikeout. But if it's someone not filing documents they're supposed to or evidence repeatedly, you may be able to get a strikeout there. And if the tribunal considers there's no reasonable chance of succeeding, so if you have an application brought against you and your solicitors consider it and say this application has no merit and no chance of succeeding, you can ask the tribunal whether they will strike out the claim on the basis it has no prospect of success. Having said that, issues should be narrowed where possible, and that the overriding objective can be used to try to narrow those issues, you should try to continue to engage and explain the position to leaseholders. So try to keep your process open, try to make them understand what you've done and why you've done it, try to be transparent and engaging at all times. Not only will that help in hopefully bringing you back in favour with these leaseholders and helping them to understand why you've done what you've done, but it also engenders some goodwill with the tribunal if you show that you're trying to engage with them and help them deal with the issues. So be seen to be engaging with the leaseholders to resolve the dispute. That feeds into what we've said above. And if the leaseholder is acting unreasonably, consider a cost sanction. And I've already discussed that and how you're not necessarily that likely to get a cost sanction, but threatening a cost sanction may, in fact, be enough to make your leaseholder stop acting unreasonably. And that, I think, is the end of the slides. Neil, have you had a chance to look at the questions? Although I don't think we've got a huge amount at present.
No, I'm just going to look at it now. So the question is, if parties were going to look to a maybe an arbitration or mediation before going to the tribunal, and the parties were happy to pursue that, is there any particular arbitrator or person that the parties should look to get some sort of agreement? I don't think there is. I think that it's really what can be agreed between the parties, and ultimately, if there is an agreement that can be reached, I know you can. As I say, I mean that the lease won't override the jurisdiction of the tribunal, but the lease might still try to suggest a route or mechanism for arbitration in the first place. So it's always worth looking at the lease. Otherwise, there are certain specialist mediators out there who offer their services that you might want to use. I don't know, Zoe, have you got anything else to add to that?
No, not necessarily. I mean, I do see your point that service charges, for example, are very technical, but if you've got lawyers or if you have a good understanding of those technical issues, then a good mediator will, while might not necessarily understand them in detail, will be able to help with that. So it's not necessarily that they need to be able to understand everything. You just need to find a good mediator. I'm just looking at the next question.
So it's a good one about practicality. So the question is, if a leaseholder raises a challenge, is it the responsibility of the leaseholder to put together the bundle in the FTT and provide the landlord with the copy? The reality is that a lot of the time the tribunal will put the onus on the landlord, particularly as they are a professional landlord, and expect the poor old leaseholder to really just feed into it and bring challenges and agree it, but not actually put together the bundle itself. So it's unfortunately, it's a bit wishful thinking that you might just be able to leave it to the leaseholder to put everything together. So our experience is, I don't know, Zoe, yours is any different, that it tends to be the landlord who gets stuck with putting together bundles.
Yes, it definitely does. I mean, you can see that both ways. Putting together bundles are a bit of a nightmare, but equally it then gives you control over the documents that are in it, because if a leaseholder produces it and they don't fully understand the issues, for example, they might not include all the documents and the evidence that you actually want to rely on and put in there. So I think actually, whilst it's a challenge to have to put together a bundle, sometimes it's good to have control of that, because you then know that the documentation that you want to rely on will be in there for you to rely on at the hearing.
Yeah, that's a really good point.
And that's it on questions, unless anyone wants to ask any more. We've never had this. We normally have loads.
No, we must have been so good in answering them. Well, yeah, I mean, I think that's it. So hopefully keep an eye out for our next webinar, and we'll see you then. Thanks a lot.
Thank you for listening. Bye.